Good evening, or morning, or afternoon. Hello. How is everybody doing? Hello, StreamYard. Hello, the 1-1, Gator Boy, Toe Cramp, Techno Slega. Okay, interesting. Hello, everybody. Hope you're all well out there. Doing an update on GTII, as I promised. And I'm going to write myself a note because I want to do a Tesla update too. Tesla update. I'm not going to do it today. Okay. I hope everybody's well. Sorry about that. So since the last live stream, of course, there's been some additional goings on. Before I go into that, just to remind you where we were last time, I think I talked about Justine Reichman filed some objection to the disputed shares, objecting to jurisdiction. Of course, I in the past said they should have sued directly in California, but that's neither here nor there. So that's pending. And then the deposition of Luke Rabari was set, or at least initially set, for mid-November, and that's the last thing. And then what happened was a couple of attorneys who apparently represented GTII filed objections to the proceedings trying to terminate their share ownership. And that's what we're going to talk about when we get to it. Before we start with that, and those attorneys, by the way, to give them full credit, and this I'm just reading from the documents that have been filed. This was filed on the 16th, and I have something that's filed on the 17th that I'm going to talk to you about. But the name of the attorneys, I hope I've pronounced them correctly because I want to give them full credit for their filing. Scott B. Oliphant, Olifant, and I don't know if he has an office or he's working out of his house. I can't tell. And Warren Markowitz, you've heard his name before. He was the attorney for GTII. I think he was involved or was aware of the situation with the dividend, and perhaps there was an erroneous box checked that sounded like it was just a not a real company, just a shell. And then there's also reference to CYA, cover your ass. Is that what it is? Oh, I don't know. CYA-esque Holdings, LLC. That's what it sounds like. And apparently that's a company, I think, by these papers, at least by my reading of these papers, it's a company owned by Markowitz. And these were all lawyers affiliated with GTII, and they are making a stink. And then there's going to be a response, and it's going to be interesting because it'll give you a flavor for what was going on and what these guys were doing. So before I go there, I hear always, and it kind of pisses me off, I hear the reference to antivirus, and I never have heard any reference to an uncle virus. And I don't think that's fair, but that's my problem. What's the difference between a vacuum cleaner and a lawyer riding a motorcycle? The vacuum cleaner has the dirt bag on the inside. And it doesn't apply to everybody, by the way. So this is just kind of general jokes. What's the difference between a lawyer and a jellyfish? One is a spineless, poisonous blob, and the other is a form of sea life. And last but not least, what does a lawyer get when you give them Viagra? Taller. Think about that joke. So I told you about the Luke Rabari deposition. We'll see where that goes. And here's the filing by Oliphant and Markowitz. So Markowitz claims in these papers that were filed on the 16th. Now, the papers were prepared by Oliphant. Oliphant is representing Markowitz and CYA Holdings. What a dumb name, by the way, in my opinion. That's not going to raise suspicion or getting people pissed off. Oliphant apparently is an attorney in Nevada, and Markowitz is an attorney in New York. And you may have had something, I know you've had contact with Markowitz. So what the claim is basically, and they filed this on the 16th, is you haven't laid out a claim to block our shares. Oliphant claims that he performed services, although he couldn't remember He provided like a one-page answer that he provided, I think. He didn't provide or couldn't remember if there was any kind of retainer agreement. And he indicates that he was hired by Markowitz, not by anybody at GTII, by Markowitz, who was the in-house counsel. And at one point in time, I'll get to it when we get to the letter. So he's filing an objection, basically saying that the court hasn't the court doesn't have jurisdiction over him, and he had argued about that before. And he claimed that these shares were for services provided. He claims, and what this claims is Markowitz got shares for being a in-house counsel for GTII. I have no, not in-house counsel, general counsel, higher status. I don't know what he was doing, because if you look at the track record of GTII, none of the deals got transmitted. They got sued many times. There appeared, based upon the receiver's reports, to be shenanigans going on involving, there was some round of shares where David got some, and I think it was like a $2 million transaction. David got some of the shares. Markowitz got some of them. I know that the receiver, and you will see it's more specific in the receiver's letter, but the receiver questions Markowitz's what he's done, period. Apparently, Oliphant, and I don't think it's the same guy as the actor, but Oliphant had at some point in time also generated an opinion letter letting Markowitz apparently sell his shares or let him become unrestricted. And Markowitz did the reverse back to Oliphant, apparently. There's also a disagreement in terms of the amount of shares they have. Apparently, Oliphant says he has 12,500. I think the receiver says that it's referenced as 125,000 shares. Markowitz, my understanding, is significantly more than that. But so the basic argument by Oliphant is that he performs services, valuable services on behalf of GTII. I have no idea what these valuable services were, but part of it also is in his position with GTII and knowing management, he became aware of all the nonsense that was going on and should have been aware of the nonsense that was going on at the time. Now, Markowitz, and I'm reading briefly from their declarations, and they're very brief. One thing I noted right off the top is this document's prepared by Oliphant, and on page 1. So this guy, this is why I referenced this as I referenced it. So this guy is filing something with the court, and you will see that his status is not so pure according to the receiver, but he's filing something to the court and claiming that he provided valuable services to GTII, and that's why he's entitled to the shares. And in the very first line of his pleading, page 3, I'm just going to read it. Scott Oliphant provided legal services to GTII for the share he received. Now, that should have been shares. So that's a typo in the very first line that he's submitting to a court, trying to establish the validity of his shares he provided based upon the high quality of work he provided. And in the very first line, he's got an error that he didn't catch or didn't pay attention to or didn't care about, whatever. So when I see that, for somebody who's trying to get relief, it doesn't really think that it makes me question the caliber of the work product that would have been provided if it had been provided. It also makes me question the caliber of counsel, period. Markowitz, I think the receiver has more problems with. But the very first thing, there's an error right in the very first thing. So this has been submitted to the court. Now, what was the response? The response is very interesting. So, trying to be fair, as I've said, this response comes from Dylan Siciliano from Garment Turner Gordon. And, I've said good things and bad things. So here we're going to focus on something good. So when he got this filing from the two attorneys who, I don't know what they did for GTII. I don't know what benefit GTII got out of it. I would think that from the receiver's reports that GTII got a negative benefit. But here's the letter. I'm not going to read the entirety of it, but here this is from Dylan Siciliano to Scott B. Oliphant at his address, and that could be a home, could be a basement, I don't know. Dear Scott, I write on behalf of the receiver. Your attempt to represent Markowitz, GTI's former in-house counsel, and CYI-esque Holdings LLC in matters adverse to GTII creates a non-consentable conflict under Nevada rules and independently violates the advocate witness rule. And again, I guess the rules in Nevada, it's not as clear cut in California, but if you're an attorney and you're in a case and you're also going to be a witness, especially if you're going to be a percipient witness, you're discouraged from representing because your credibility will be in question as a witness, and that can hurt your client when you're advocating for them. So it's generally not, it's frowned upon to do that, but apparently that's not important. And also then the receiver reminds the attorney that the attorney-client privilege is not his, it's GTII's. And what in essence that is said because the attorney is in essence trying to describe what he did and circumstances and has information that he probably needs to keep secret and not disclose it in legal proceedings, because that would be a violation perhaps of the attorney-client privilege, which is sacrosanct. It's very important, let's just say, to lawyers. The attorney-client privilege is the most important thing a lawyer has to protect. So then it goes in to say that you were outside counsel since your early 20s. You defended litigation brought by International Monetary that was prosecuted by Alex Calloway, I think he's referring to, plaintiff's current counsel, that resulted in a significant liability to GTII. So the work he did ended up the result was bad. That's kind of what it's said here. Additionally, you became aware of facts during the litigation that were problematic for both GTI management and Markowitz. You also represented GTI against David Wells in a lawsuit brought by Ms. Pham, who incidentally also represented GTII. So in essence, what they're claiming is that in your relationship, besides the conflict that obviously exists, in your relationship, you were aware of nonsensical activities that were going on that were contrary to the interests of GTII. And you should have not only helped, but removed yourself. And based on the evidence then available to you, I'm reading this from the letter, you should have been aware that Markowitz engaged in conduct that violates security regulations and caused significant injury to GTII. So that's what the receiver's counsel is saying, and these guys are trying to keep their shares. And this guy apparently is operating in a direct conflict of interest where he represented GTI in one matter, and now he's trying to represent somebody else in an adverse situation. Doesn't sound like this guy's really concerned about his obligations, but maybe he is, maybe he is. But I'm going to read you something at the end that maybe will have you think differently. And the letter goes on basically to say, you have a conflict of interest. You shouldn't be acting here. There's a significant risk of harm to GTI if you release that information. You can't act as a witness and a lawyer in the same case, especially when you're adverse to your former client. And give us the dates for your deposition. So I want to take the deposition of Markowitz and of this guy, Scott Oliphant. And that's what they want to do. So that was the response to the thing, to the request or to the challenge about that these shares should be retained by these guys, both these guys who did such a fine job for GTII, as you can tell, because we're having this conversation. And attached to the papers was some emails, and one is dated in September, I believe. And it's a response. So the receiver is reaching out after he got involved, because he got involved September 24. And this is the response of the attorney I just referenced, Oliphant. Mr. Strickland, I have no money or assets of GTII. I do not recall if there was a retainer agreement or an engagement letter. My work for GTII ended well over a year ago. I was asked to do work for GTI by its house counsel, Mr. Markowitz. That is it. There's nothing more. And the response is you haven't answered all the questions because the receiver had a much broader questions. Now his response, this is September 30th of 2024. Listen to this response from Mr. Oliphant, who I don't know if he has an office or he works out of his home or out of his basement. I don't know. Hard to tell. Mr. Strickland, I now seek to disabuse you of your arrogance, whatever the source. The court order is irrelevant to me. The court has no jurisdiction over me, and I do not have to comply with your whim or caprice. Hence, I have extended all the information that I have to this point as a courtesy, not an obligation. Now, however, you have shown such an overwhelming degree of condescending arrogance, I will not respond further to this correspondence orders, edicts, or other purported commands with respect to your status as a receiver for GTII. Thus, as I stated previously, we are done. And that's Scott Oliphant. Can you imagine? This was his email dated September 30th, 2024, where he completely disregards the power and abilities of the receiver. He just filed something in October of 2025 with the same court. Do you think there's any chance that this particular email is going to show up in the opposition of the receiver, and that the receiver's counsel is going to bash this, that Mr. Oliphant, who I don't know what he did for GTII because he doesn't delineate that, and he certainly didn't, based upon what the receiver said, didn't do anything that resulted in a positive effort, or at least nobody's stated that to this point in time. I can imagine if you presented that to a judge where you said, your order is irrelevant to me and you have no jurisdiction to me, I would think that I would be concerned going in front of that judge. I would, because I would think that judge would be pissed. And I don't think that judge would take too kindly for that. And I would think Mr. Markowitz would think the same thing, that if Mr. Markowitz chose a guy who basically told the court to F off, that may not be a good approach to approach the court. And, there's a response to that one where basically Oliphant says, F you, I'm not going to have anything to do with you. The court has no power with me. I don't respect the court's order. After that, he says that, you're a member, been a member of the Nevada Bar for 24 years. You're aware you're subject to the court's order, and the court likewise has jurisdiction over you. And if you don't follow this, and I'm now interpreting, if you don't follow this, I'll go to court and get an order. And that was the response. And they also apparently didn't respond, or I think one of the parties that was late in responding for the audit certification kind of suggests that this guy is one of those parties who dicked around. Now can't tell it for sure, but kind of reading between the lines, it seemed like he might have been one of the guys who was dicking around and slowing the certification process. There's also an email, and I don't know what this is for, May of 2025. And this is also to this guy, Oliphant. Again, I don't know if he has an office or he works out of his basement or his garage. I don't know. I understand that you're attempting to convert your book entries into certificate shares. We'd like to understand the purpose, as it's an irregular request under the circumstances, and especially given our recent conversations. It's probably best we communicate in writing to avoid any misunderstanding. Interesting. I don't know. I do not know what Mr. Siciliano is referring to, but it doesn't sound like that the conduct was consistent with what the conversations was. And then there's a response back saying, I don't think that was irregular, but that's where it ends. So in light of that, especially that one email where I referenced, where basically Oliphant, who represents Markowitz and himself and CYAS Holdings, basically says he's not going to respect the court order and says for the court to F off and for the receiver to F off. I'm interested to see how that plays in court. I think it'll be really interesting. And I wait to see how the court views this response. There will be, again, an opposition, I presume. There'll be an opposition or objection filed by the Receivers Council. I expect it to be very entertaining. And as you see, we're getting filings in from various parties. All have been identified, I think, in the receivers report for various issues, and they're trying to keep their shares. So I found this interesting just in light of the communication, where I think Mr. Oliphant stuck his foot up his ass, really, his own ass. And that really hurts, because your leg doesn't really turn well that way. But I think, if he had it all over to do it again, I don't think he'd send that email. And I guarantee you that email is going to come up, and it's going to be very entertaining when it comes up, when I see the way that he justifies that. I guess the best way, if I were in this position, I would say, if I were him and I was in front of the court and the other side brought an email that I had written, I would say is, Your Honor, I'm an idiot and I apologize. And I don't know, I was out of my head at the time. I was angry and I wrote something I shouldn't have written. There's no reason I should have written, and I apologize. And that should be his approach. But I doubt if some guy who can't even spell shares correctly in the very first line of a document where he's trying to get his shares, I doubt if he's going to take that approach. I think he's going to try to justify, and he'll just piss off the judge more, which is nice because that Markowitz is attached to him also. And I don't know if Markowitz even read this paper. I mean, if I would have read this, I cut that share thing the very first time I read it. So whatever. Anyway, that's all I got to say about these clowns, as I'm calling them. Just to finish out, what's the difference between a lawyer and a gigolo? A gigolo only screws one person at a time, most of the time. How do you get a lawyer out of a tree? Cut the rope. And last but not least, justice is blind, as we all know. So please don't pet its dog. To all you out there, have a great day. That's the current news. I'm sure next week we'll have more news, because it's, I think we're in the time where these claims and disputed shares are all being kind of discussed. So I expect more filings, more depositions probably. I think the documents from Frank B will be coming in soon. And that's where we are. And I know John Forster is still following events, still waiting, I think, for, as far as I know, waiting for the Receivers Council to go forward. But obviously activity is ongoing, and I will report as we go on. For all you out there, have a great weekend. Be well. Take care of yourself. Talk to you soon, and see you later.